We all know drinking and driving is a bad idea, but can the police arrest you for DWI when you were never driving? What if you're under .08? What if you only had something to drink after you were driving? Here are 3 crazy ways police can arrest and charge you with DWI. Number 1, cops arrest you for DWI and you were not even driving. Imagine being in your house, relaxing, maybe watching TV, and all of a sudden the cops come up to your front door. They ask you to step outside because they want to ask you questions because you're under suspicion for DUI. Maybe you're actually a mile away from your car. Maybe your car ran out of gas and you're going to walk toward getting that gas. And now a police officer walks up to you and they want you to perform field sobriety tests and possibly arrest you for DUI. How is it even possible this can happen? Well, the way to answer this question is to first break down the elements of DWI. Under Texas law and most other states in the country, the government must prove beyond a reasonable doubt that not only were you intoxicated, but that you were operating a motor vehicle at the time. Now, what does that mean? Well, that's the key word. Notice it doesn't say driving, it says operating, which means technically the government could claim if you are in some way using the vehicle in some capacity, that now you don't technically have to be driving in order to be charged with a DWI. How is this possible? Well, one of the best ways I can illustrate this is to share with you the story of a client I represented by the name of Steven. Now look, he had come into downtown Fort Worth. He wanted to catch a show at a local comedy club. So he was there, and of course, like many people do, he had several drinks and he had a good time. And then as he left the comedy club, he went back to his parking space where his truck was parked, and he realized he had had a little too much to drink. So at that point, what did he do? He got on his phone, he ordered an Uber. But because it was mid-July in Texas, and it was 1,000 degrees outside, he decided he was going to get in his car, turn on the car, and now use the air conditioning so he didn't burn to death in the Texas heat, and wait for the Uber driver to show up so that he could get a ride home. Now, understand this. Steven was parked in a parking space surrounded by curbs. So the only way he could have actually gotten out is he would have had to have backed up his truck in order to drive away. And so all he did is, as he sat there waiting for the Uber to arrive, of course, a bicycle cop in downtown Fort Worth rides up on his bicycle right up close to him. And Steven had his window down, and the cop asked him, "Hey man, what are you doing?" And of course, Steven was trying to be nice, and he said, "I just went to the comedy club, but I'm actually waiting for an Uber to show up here." And that's when the cop decided, "Hey buddy, I need to have a little bit more of a conversation with you because now you are under investigation for DWI." Think about this for a second. Steven was only sitting in his car with the air conditioning on, waiting for the Uber to show up. In fact, while the cop was talking to him, the Uber driver drove up and tried to engage with him so that he could leave and go home. The officer waved off the Uber driver, and now he placed him under arrest for driving while intoxicated. Why? Because according to the officer, he was operating the motor vehicle. Was he driving? No. Was he causing a threat to anyone or any problem to anyone? No. Was he operating the motor vehicle? I don't know, you tell me what you think in the comments, but the officer decided he thought he was. This is the key point. In order to determine whether or not he was actually operating the vehicle, that is what is known as a fact issue that a jury can decide. Now, there is some case law that's out there that says in Texas that you sitting in your car just running your engine with your air conditioning on could be seen as operating if the jury agreed as such. So as a result of that, that's why the police officer did what they did and charged my client with driving while intoxicated. Now, this is another example of a lawful but awful situation that cops engage in. Could the officer have just let him get in the Uber and take his ride home? Absolutely, he could have. But instead, what did he decide to do? I'm going to hit my quota, I'm going to take this guy into jail, and I'm going to let the DA sort it out as to whether or not he was operating. Now, could the police officer arrest Steven for what happened in this situation? Technically, yes. All the police officer needed was probable cause in order to place him under arrest. What does that mean? Well, probable cause basically means the police officer can view whatever is in front of him. And if he believes it's more likely than not some type of criminal activity might be taking place, he can now place him under arrest and haul him into jail. So what is my point? It's really easy to get arrested if a police officer engages with you and believes that it's more likely than not some criminal activity is going on. Why? Because cops don't actually have to prove that you committed a crime. They only have to think that it's more likely than not you did. Now, to be convicted of DWI is a whole different story, because there a prosecutor must prove beyond a reasonable doubt the elements of the crime of DWI. However, it's much easier for officers because they only need probable cause that you were operating the vehicle. And they usually get probable cause from one of two places. Number one, from a witness who was present and can say that you were operating the vehicle, or from you. The number one way they get this information is by trying to get you to admit that you were either driving the car or that you had been operating the car in order to arrest you. Think about accident cases. When cops show up at the scene of a car accident, how do they know what happened? Well, the first thing they want to do is they want to ask all the witnesses and everyone involved what exactly they saw. But the primary way they can establish if you were at fault is that they will come to you and they will ask you questions, hoping that you will share information that they can then turn around and use against you. Now look, it is legal in every state to go out to dinner and have a glass of wine or have a drink with your meal. However, if you then get in a car accident on the way home and the officer walks up to you and he smells the odor of alcoholic beverage, or you admit to having a drink, they're not going to telegraph to you that they are now investigating you for DWI. Instead, they are going to begin asking you very specific questions, hoping that you will open up to them so that they can determine, number one, so they can believe you're intoxicated, and then number two, so that they can establish that you were operating the vehicle. So, if cops come to your front door and they start knocking on the door, or they pull up next to you and start asking you questions that seems to be a little weird, understand what they are doing. When they ask you things like, where have you been? Where did you come from? Do you know anything about this anonymous call we received about you driving erratically back there? No, they have set the bait, hoping you will bite in order to say anything at all that they can now use against you to establish probable cause to arrest you for DWI. In fact, that client I spoke about earlier, Steven, the bicycle cop, when he rode right up to him, the first thing he said to him was, "Hey man, I sure do like this classic truck. It's yours, right? You about to drive home? And there's nobody else with you, is there?" He was hoping that Steven would talk so that he could use his own words against him to prove that he was operating the vehicle. Now, prosecutors are likely to subpoena any witnesses who might be able to place someone behind the wheel or operating the vehicle. But if there's no one else present, you opening your mouth could be the actual nail in the coffin for a conviction for DWI. How did it turn out for Steven? Wait around till the end of the video and I'll lay it all out for you. Number two, cops arrest you for DWI, you cooperate with the investigation and blow under .08, and you still end up in court. Now look, everybody says this. Cooperate with the police. If you give them everything that you want, if they determine that you're not intoxicated, they'll just let you go. Case dismissed, right? Well, let me break this down for you. The best way to do this is to first look at what type of breath test you gave. Did you give a portable breath test on the side of the road? Or did you give the big beast breath test that many people refer to as the Intoxication 9000? Look, if you took the portable breath test on the side of the road, and even if you blew under the legal limit, many times you're still going to be arrested. Why? Because cops offer you the portable breath test primarily to verify what they already believe, that they think you are drunk. Cops know that the portable breath test is not admissible in court because it has been proven to not be scientifically reliable in court, but they offer it to you anyway, primarily because they want to validate their belief that they think you're intoxicated and to try to show that maybe you've had something to drink or that you're lying when you told them you didn't. Now, what if you provided a breath test at the police station using the big beast Intoxication 9000? Here, it requires us to break down what the actual definition of intoxication means. Now look, under Texas law and in many other states, in order to prove intoxication, it can actually be shown in one of three different ways. One is to be .08 or higher at the time of driving, your blood alcohol level. The other option is to have lost the normal use of your mental faculties, because of alcohol or drugs, or to have lost the normal use of your physical faculties because of alcohol or drugs. Now, this is where police usually arrest you, even if you completely cooperate with them. Think about it for a second. If you cooperate and you provide a sample of your breath, and it turns out you're over the legal limit, you already know you're going to jail there. But if you provide a sample of your breath and you're under the legal limit, they now still have the opportunity to have you do those field sobriety tests on the side of the road, which you have a right to refuse. And then they can use that information against you to now try to establish that they don't believe you had the normal use of your mental faculties or your physical faculties and still haul you into jail. So how do the cops establish evidence that you do not have the normal use of your mental faculties or physical faculties? Well, one of the ways they do it is by having you talk. So if you begin to open your mouth, and now they'll claim you have slurred speech, which is why you have a right to remain silent and you should exercise it. The other way they could claim you don't have your physical faculties is to have you walk a line or maybe hold 1 foot up and count to 30. Well, now that's because that's part of a field sobriety test, which you also have a right to refuse on the side of the road. They also have a host of other items, literally clues that they have listed on their paperwork when they're doing a field sobriety test and they're administering a DWI investigation, where they're looking for things like strong odor of an alcoholic beverage, slurred speech, unsteady on their feet, didn't really respond quickly when asked for their driver's license and insurance. So please understand, everything that you do in that interaction is being judged as to whether or not the officer thinks you have normal mental or physical faculties. By the way, what is normal? Is what normal is for you normal for me? Understand, it's very much an opinion, and the officer is judging everything you say and do to determine if you have your normal mental or physical faculties. Notice what's happening here. Your freedom hangs in the balance based upon a police officer's opinion. This is why it's so important to make sure and have the body camera, the dash camera, so that you compare whether or not you actually show these signs. Or better yet, don't provide the information when the police officer asks for it. In fact, during a traffic stop, when a police officer approaches your window, you are under no obligation to have a conversation with him. The only thing that's required for you to do is to provide a copy of your driver's license and your insurance. And you can exercise your right to remain silent, and it is absolutely within your rights to refuse field sobriety tests. Remember, all of the field sobriety tests on the side of the road are completely voluntary. And many times I see that no good deed goes unpunished. I've seen scores of people, maybe they've got health problems, they've got a bum knee, maybe they're just terribly coordinated, and they want to get out there and eagerly prove to that police officer that they are not intoxicated. And then the only thing we end up finding is that the police officer finds every little misstep and small problem that he sees, he ties that into meaning they must be intoxicated. Look, at the end of the day, .08 is a per se rule that both police and prosecutors are looking for to make it easier to convict you of DWI. But DWI cops don't need that number in order to arrest you and take you to trial. But never forget, the government always has the burden to prove beyond a reasonable doubt that you are intoxicated. And if you have a number under .08, it's important to realize that can empower a really top-notch DWI attorney to potentially go in there and either get your case dismissed or maybe obtain a not guilty verdict at a jury trial. Number 3, cops arrest you for DWI, but you were only drinking after you drove. In some states, like Pennsylvania, it is not a defense to DWI that you had been drinking after you were driving. In fact, in a few of those states, like Pennsylvania, all the government has to prove is that you were intoxicated at the time you gave a sample of your breath or blood, which is precisely why you need to understand you have a right to refuse giving a sample of your breath or blood, which would then force the police to obtain a search warrant in order to gather that from you. Now, in almost all other states, it is absolutely a defense to DWI that you were drinking after you were driving. Think about this for a second. Let's say you drove home from work and you pull into your front yard and you walk inside and your wife throws you to a surprise birthday party and you got all your friends there and your buddy walks over and hands you a drink and You start downing a few drinks, you're having a great time, all of a sudden the cops show up at your front door. This usually happens because some person doesn't like the way you were driving, or maybe you get into some sort of road rage situation with someone and they call the cops, and the cops show up already believing they think somebody must be intoxicated here. But it only makes sense. You should not be able to be arrested and convicted of DWI for only driving and then parking and having something to drink. But cops will likely not believe your story when you tell them you had only had something to drink after you were driving. That is precisely why I have done a video explaining it's so important not to answer your door when the cops come to your front door. Police can only ever enter your home if they either have a valid search warrant, something known as exigent circumstances, or your consent. Otherwise, they're only there on a fishing expedition, and there's no fish to catch if you're not biting. Even if cops claim they have a search warrant or exigent circumstances, you still have a Fifth Amendment right, and you can and should exercise your right to remain silent. Otherwise, cops are going to start asking you very strategic questions they have been trained to ask in order to gain information from you in order to use it against you. For example, there's some very common questions that they ask. They will ask things like, hey man, did you have anything to drink? How many drinks did you have? When was the time of your last drink? Have you had anything to eat tonight? If you choose to say, officer, I exercise my right to remain silent, the officer can now no longer twist or use your words against you to establish a DWI investigation. For example, many times police officers are trained to come to you and say, look man, I can't help you if you're not being honest with me. They will then ask you the question again, did you have anything to drink? How much did you have to drink? Just tell me a little bit about it. And then what happens is, particularly on this question, they'll ask, what time was your last drink? And many times people will want to make it seem like as far away as possible when they had their last drink. But the officer will then say, well, I still smell some odor of alcoholic beverage on him, and I still think he seems to be unsteady on his feet, and I'm sizing up what I think his response time is to me when I'm speaking to him, and all of those things can be used to be written down on a police report to establish his opinion that you do not have the normal use of your mental or physical faculties. I know I say this all the time, but I want you to understand the officer is there not to be your friend. He is there to conduct an investigation, and everything you say and everything he gathers will be used against you. And the reason why I bring this up is because why do these questions even matter? Who cares what you had to eat that night? Who cares when the time of your last drink was? And this is critical. The police and the prosecutor must show that you were intoxicated at the time of driving or operating the vehicle. The further out in time you give a breath or a blood sample, the less reliable that breath or blood sample is at the time of trial, unless the police can go back in time. This going back in time by the prosecutors and police is what is known as retrograde extrapolation. This pseudo-scientific way of attempting to go back in time and estimate what someone's blood alcohol level was is based upon the answers to many questions that you give. And many times it's admissible in court even if the breath or blood test was given 4, 5, or 6 hours later. How do cops obtain this information to go back in time? They obtain it from you. But if you choose to keep your mouth closed and not answer the officer's questions, they are not able to obtain this key information that they're fishing for on a DWI case. Number of drinks and time of last drink. On the other hand, if you choose to talk to the police and answer these questions, the police can now take this information, give it to the prosecutor, get with a toxicologist, and the toxicologist will be allowed to get up on the witness stand at a jury trial and make an estimate that they believe you were intoxicated at the last known time you were operating the vehicle. Think about that. You might have only been drinking after you were driving, but because you answered those questions, that officer is able to use that against you in a courtroom. Police are guessing here, and guessing is not evidence. And courts do not allow this retrograde extrapolation, going back in time business, unless you provide the police this information. Lesson here, don't talk so much. You have a constitutional right to remain silent. You don't have to feel bad by refusing to answer the police officer's questions. Now, I mentioned earlier that Stephen was arrested for a DWI for sitting in his car, his truck, with the air conditioning on, waiting for an Uber. How did it turn out for him? Well, we pushed the case all the way up to a jury trial. And during the trial, the jury believed that Stephen was not operating a motor vehicle. In fact, they believe he was doing the responsible thing by choosing not to drive and making sure that the Uber driver came to pick him up. Sometimes the only way to stop the police from doing the lawful but awful is to send a message by going to a jury trial and making sure that the community establishes the type of policing we all want. Now, what if a cop is pressuring you to give a breath test? Check out this next video where I do a deep dive into the 8 things you don't know about breathalyzer tests. See you over there.